If you leave money directly to your children when you die, there is a 50% chance a divorce court will hand half of it to someone you have never met. That is not a worst-case scenario. That is the national divorce rate applied to your estate plan. And the way most wills and trusts are written today, the money you worked 40 years to build has zero legal protection the moment your child deposits it into a joint account with their spouse. Think about that for a second. You spend your entire career building a retirement account, paying off a house, accumulating an investment portfolio, you update your will, you name your children, you do everything right. And then 15 years after you are gone, your daughter-in-law files for divorce, and your son's attorney looks her in the eye and says, there is nothing we can do. Half of what mom and dad left you belongs to her now. This happens every single day in family courts across the United States, and almost no one plans for it. My name is Marcus Webb, and today I am going to show you exactly how inherited wealth becomes marital property, how divorce courts divide it, and the specific trust structure that prevents your children's inheritance from ever appearing on a divorce settlement table. The story of Carol and David. Carol and David Morrow spent 37 years in a suburb outside of Columbus, Ohio. David was an engineer. Carol was a school administrator. By the time David passed away at 72, they had built an estate worth $800,000, a paid-off house worth $310,000, a retirement account with $420,000, and a joint brokerage account with $70,000. Carol updated the estate plan after David passed. She named both of her children as equal beneficiaries, her son Michael and her daughter Jennifer. Each would receive approximately $400,000 when Carol died. Carol passed away in 2022. Michael, who was 44 at the time, received his $400,000 inheritance. He was married to a woman named Brittany. They had been together for 9 years and had 2 kids. Michael loved Brittany. There was no sign of trouble. Michael did what almost everyone does. He opened the inheritance check, deposited it into their joint checking account, paid off a chunk of the mortgage, bought a new truck, and put the rest into their shared investment account. 18 months later, Brittany filed for divorce. Michael's attorney asked him one question: where is the money your mother left you? Michael said it was in their joint account, in the house equity, in their investment portfolio. The attorney paused, then he said, I have to be honest with you, that money is no longer separately protected. When you deposited it into your joint account and used it to pay down the marital home, you commingled it. In Ohio, commingled inheritance loses its separate property status. Brittany's attorney is going to argue that half of it is hers. She did, and she was right. Michael walked out of that marriage with less than he walked into it. The $400,000 his mother had spent a lifetime building vanished into a divorce settlement. Why inherited money is not automatically protected. Here is what most people do not understand about inheritance and divorce law. In the United States, most states treat inherited money as separate property when it is received. That means if you leave your son $400,000 and he receives it while he is married, that inheritance belongs to him alone, not to the marriage. That protection, however, is not permanent. It depends entirely on what the child does with the money after they receive it. The legal concept that destroys inherited wealth in divorce courts is called commingling. Commingling means mixing separate property with marital property so thoroughly that a court can no longer distinguish between the two. When Michael deposited his inheritance into a joint bank account, he commingled it. When he used it to pay down a mortgage that was in both his and Brittany's names, he converted separate property into marital equity. When he moved the remainder into a shared investment account that both spouses contributed to over the following year, he made it legally impossible to trace what was inheritance and what was not. And once a court cannot trace separate property back to its source with clear documentation, it defaults to treating the assets as marital property subject to equitable distribution. The problem is not that the law is unfair. The problem is that no one tells parents about this before they write their will. How divorce courts divide inherited wealth. Different states handle inherited wealth differently, but there are 2 broad patterns. In common law, property states, which is most of the country, inheritance is separate property as long as it remains separate. The moment it is commingled with marital assets, it becomes divisible. Courts look for a clear paper trail. If the money moved into a joint account, a joint investment, or was used to improve a jointly owned asset, the protection is gone or severely weakened. In community property states, including California, Texas, Arizona, and several others, any income or growth generated by an inheritance during the marriage may be treated as community property, even if the original inheritance was kept separate. The underlying asset may be protected, but the earnings it generated during the marriage are fair game. What this means practically, in almost every state, inherited wealth can end up in front of a divorce court if the inheriting spouse handles it incorrectly. And the way most people handle it, depositing it into joint accounts, using it for shared expenses, investing it alongside marital savings, is exactly wrong. The solution your estate attorney is not telling you about. There is a specific trust structure designed to solve this problem completely. It is called an inheritance protection trust. Some attorneys call it an asset protection trust. Some call it a spendthrift trust. The specific name matters less than the structure. Here is how it works. Instead of leaving your assets directly to your children outright, in cash, or in a simple transfer, you leave them inside a trust that your child can benefit from, but does not legally own outright. Your child is named as the beneficiary of the trust. They can receive income from it. They can receive principal distributions for specific purposes, education, housing, health, business, investments. They can live off of it, invest it, grow it. But the trust itself, the legal entity that holds the assets, belongs to no one in the marriage. It is not a marital asset. It cannot be divided by a divorce court. It does not appear on a balance sheet in a settlement negotiation. Because your child does not own the trust outright, their spouse cannot claim a share of it. The key provision that makes this work is called the Spendthrift Clause. A Spendthrift Clause prevents the beneficiary from voluntarily transferring their interest in the trust, and it prevents creditors, including a divorcing spouse, from reaching the trust's assets to satisfy a claim. Courts in virtually every state recognize and enforce properly drafted spendthrift provisions. The trust is drafted by an estate planning attorney. It names a trustee, often a bank, a trust company, or a trusted family member who is not your child to manage the assets. The trustee makes distributions according to the rules you set in the document, and the divorce court cannot touch what the trustee holds. Michael's situation would have looked entirely different if Carol had used an inheritance protection trust. The $400,000 would have sat inside the trust after Carol's death. Michael could have drawn income from it. He could have received a distribution to help with a down payment on a house paid directly to the title company, not into a joint account. He could have accessed it for healthcare, education, or business investment. But Brittany's attorney could never have put it on the table. It would not have been a marital asset. Because Michael would never have owned it outright. What makes an inheritance vulnerable? The 5 Cummingling mistakes. Even with the best intentions, children destroy the legal protection of their inheritance in 5 predictable ways. Mistake number 1. Depositing the inheritance into a joint bank account. This is the most common and most devastating error. The moment inherited money enters a joint account, it is commingled. Courts see it as marital money. Even if the original deposit can be documented, subsequent withdrawals and deposits make it nearly impossible to trace. Mistake number 2. Using inheritance to pay down marital debt or improve marital property. Paying off a mortgage on a jointly owned home, renovating a shared house, or paying off a spouse's car loan converts separate inheritance into marital equity. Courts treat the improvement to the marital asset as a gift to the marriage, not as a recoverable investment. Mistake number 3. Titling investments in both spouses' names. Moving inherited money into a jointly held brokerage account, adding a spouse as co-owner of an investment account, or purchasing property in both names immediately converts separate property into marital property. Mistake number 4. Failing to keep records. Even when a child keeps inheritance money in a separate account, failure to document the source keeping the original check, maintaining separate account statements, creating a paper trail from the estate to the individual account makes tracing nearly impossible in court. Without documentation, a judge defaults to marital property treatment. Mistake number 5. Waiting too long to set up the trust. Inheritance protection trusts must be set up in the parent's estate plan before the parent dies. Once the money is distributed outright to the child, the protection is gone. You cannot retroactively put money into an asset protection trust after the fact and preserve the divorce protection. The trust must already exist in the estate documents when the parent passes. The trustee question. One of the most important decisions in setting up an inheritance protection trust is choosing the right trustee. The trustee controls distributions. They decide when and how much your child receives. If you name your child as their own trustee, meaning they control their own distributions, most courts will treat the trust as the functional equivalent of outright ownership. The divorce protection weakens significantly. The standard structure for maximum protection is what attorneys call a discretionary trust with an independent trustee. The trustee is independent, not the beneficiary spouse. They exercise genuine discretion over distributions, and the beneficiary cannot compel the trustee to make a distribution they choose not to make. Many families use a corporate trustee, a bank's trust department, or a professional trust company. Others name a trusted sibling, family friend, or family attorney. The key is independence and genuine discretion. This can feel uncomfortable. You are asking your child to rely on someone else's judgment for access to their inheritance. But this is exactly what creates the legal protection. Courts protect what your child does not control. Courts divide what your child owns outright, what this costs, and what it prevents. An inheritance protection trust adds roughly $500 to $1,500 to the cost of an estate plan, depending on complexity and attorney rates in your state. For a simple plan with 2 or 3 children, a well-drafted set of subtrusts might add $2,000 to $3,000 to the overall document preparation cost. Compare that to the cost of a contested divorce with significant inherited assets on the table. Attorneys' fees in a high-asset divorce in the United States average between $25,000 and $100,000 per side. Mediation alone can cost $10,000 to $20,000, and the assets at stake, assets your parents spent a lifetime building, can disappear in a settlement in a matter of months. The trust costs $2,000 to create. The divorce it prevents costs your child $200,000 and a decade of rebuilding. What about your child's current marriage? Some parents hesitate to set up an inheritance protection trust because they like their child's current spouse. They do not want to seem distrustful. They do not want family friction. Here is the reframe. An inheritance protection trust is not a statement about your child's marriage. It is a statement about the legal system. Even the strongest marriages can end. Not just in divorce, death, incapacity, addiction, financial collapse. An inheritance protection trust protects your child's assets in all of these scenarios. It protects against a son-in-law's business creditors. It protects against a daughter-in-law's student loan default judgment. It protects against bankruptcy. It protects against a predatory second spouse if your child is widowed and remarries. And if your child's marriage is as strong as you believe, if they are together 50 years and die holding hands, the trust never becomes relevant. The assets pass cleanly at the end of the trust term. No harm done. The cost of being wrong about a marriage is catastrophic. The cost of being right about a marriage and having used a trust anyway is zero. Your 30-day action plan. Here is what to do with this information in the next 30 days. In week 1, pull your current estate documents. Look at your will and your trust. Find the sections that describe how assets pass to your children. If the language says something like, outright to my children in equal shares, your children's inheritance has no divorce protection. Mark it. In week 2, call your estate planning attorney. Tell them you want to add inheritance protection trusts, sometimes called subtrusts or spendthrift trusts, for your children's shares. Ask specifically about the spendthrift clause and about independent trustee structure. If your attorney seems unfamiliar with this concept, find an attorney who focuses exclusively on estate planning and asset protection. In week 3, have a conversation with your children. You do not need to make it dramatic. You can simply say that you updated your estate plan to protect their inheritance from potential future creditors or life events, and that they should know a trustee will manage their share when the time comes. Informed beneficiaries almost never contest estate plans. Surprised beneficiaries sometimes do. In week 4, review the trustee choice with your attorney. Consider whether an independent, corporate trustee makes sense for your family, or whether a trusted individual, a sibling, a family friend, a professional advisor is the right fit. The trustee will manage your child's financial legacy for potentially decades. Choose carefully. If this episode helped you see something in your estate plan that needs to change, please subscribe and share it with someone who needs to hear it. The families who protect their legacies are the ones who plan before the problem arrives, not after. I am Marcus Webb, and your family's financial future is worth one honest conversation.